All rise and adjourn. All right, good afternoon.
Good afternoon.
I know you had a fairly heavy lunch today, so if you need to take a break at any time, please get my attention. Okay, we will take a break. All right, at this time, we will continue with the cross-examination of Dr. Stinson. Mr. O'Brien.
Thank you, Your Honor. Dr. Stinson, you examined him, as you indicated, in direct examination for purposes of this mitigation hearing, correct?
That's correct.
And you were not asked and did not ask, were not asked to examine him for purposes of competency to stand trial, correct?
That's correct as well.
And you were not asked and did not examine him for purposes of not guilty by reason of insanity at the time of the offense, correct?
That's also correct.
And based on what you said to Mr. Thomas in direct examination, I take it you did not discuss the crime itself, either the murder, the rape, the kidnapping, or robbery.
That's correct. I assumed that the facts were accurate as laid out in the discovery.
Was it important or not important to you to ask him whether he committed the offense he had been found guilty of?
Well,
Okay.
I'll withdraw it, Your Honor. I want to keep moving.
All right. Questions? Withdrawn.
Yeah, thank you, Your Honor. Did you talk with his sister, Deborah, about the use of the credit card after the offense?
I did not talk to her about that.
And when you talked to the defendant's mother, or did you talk to the defendant's mother?
I did not talk directly with the defendant's mother. I got information from the mother through others.
In terms of trying to confirm either her criminal activity, her alcohol or drug activity, or other family things that we talked about, you concluded it was not necessary to talk to her?
I don't know if I can, well, I think it's fair to say I concluded that it wasn't necessary. I had information from her through others, and I had information from other family members. So, you know, maybe under ideal circumstances I could have talked to everybody and some other people that maybe we haven't even contacted yet, but I think it was fair to say I had adequate information.
And how about the woman he was living at the Cardinal Crossing Apartments with at the time of this crime? Did you talk to her?
I did not talk to her, no.
The times in which you've talked about him having used or abused or alcohol too much, are we talking about back in the remote past, in the 80s, before he went to prison? Or are we talking about his recent release before this crime he's on trial for?
Yeah, so primarily I'm talking about when I laid out the alcohol use disorder criteria. That was when he was out just before he was arrested on this case.
And he was living with this woman out at the Cardinal Crossing Apartments, correct?
That's my understanding, yes.
And you didn't ask her whether or not he consumed alcohol while he lived at that premises, I take it?
I didn't talk to her at all. I suggested that one of the mitigation specialists or investigators contact her, and I did not hear that there was any contact with her.
Were you aware she visited Mr. Parton regularly at the jail during the time he's been awaiting trial?
I don't believe that I received any jail records. I requested those as well, but have not received them.
You were aware he was living with his mother and or sister up on 15th Avenue in Linden area, correct?
I believe that I have a general understanding of that, yes.
And when he got out of prison, they were part of his plan to come and live with them as opposed to living by himself or being homeless, correct?
I don't actually know what his plan was. I requested records from the Georgia State Prison System and did not receive those records either, so I don't know what his release plan was.
Well, during the 7.5 hours you personally interviewed him in the county jail, did you ask him that question?
Ask him what question?
What his parole plan was and whether he lived with his sister and his mother.
I asked him not specifically what is your parole plan, But I asked him if he was on, if he had to drop urine for drug testing. My understanding was he didn't. I asked him if he had a report or if he was on a GPS system. My understanding he wasn't. So I asked him some questions, but I didn't ask him like what was the specific plan.
And in fact, when he came here and was living with his mother and sister up on 15, he was on parole from the state of Georgia, not from the state of Ohio, correct?
That's correct. My understanding is he's still on parole and would be, at least at the time of his arrest, for about 19 more years.
And the parole had been transferred because he was moving from Georgia upon his release to Ohio, correct?
That's my understanding, is then Ohio would take on that responsibility when he moved here.
Now, some of the things that you testified to yesterday reference to parole, interviews and recommendations for treatment or for a halfway house or for other post-prison activity. Those were made early in his incarceration period, weren't they?
I believe the ones that I was referencing came from reports that were earlier in his prison time, yes.
And as we have heard, he went into prison in '82, I think, and got out in '06. Is that correct?
That sounds right to me.
And he maxed out, as we talked about before, correct?
Correct.
And when you max out, you're not put on parole, are you? You've done your time,
Yeah, I think
paid your debt. You're not under parole supervision when you get out, when you max out, correct?
that's correct. He did his 25 years. He was maxed out. He wasn't under parole supervision, and then he went back, I think, 93 days later.
So the fact that the parole board didn't do things that had been recommended 15, 20 years before, they couldn't, could they, when he was released in '06, for example, require certain counseling?
Well, certainly not for the 93 days he was out, but absolutely, when he got out this last time, they could have him under supervision for 20 more years, and frankly should have. The recommendations were there, the writing was on the wall, and that was one of the failures in this case.
The state of Georgia, you don't know what those conditions were, though, because you didn't see the records, correct?
Well, my understanding was they transferred him to Ohio's parole authority.
But the terms and conditions of parole would not be in that circumstance set by the state of Ohio, they'd be set by the state of Georgia, wouldn't they?
Sure, although my understanding is once Ohio assumes responsibility for him, they can put him under certain conditions as well. And again, in my opinion, should have.
In 1981, in the Dr. Smith Bindover psychological exam, did you determine from your review of that report whether he was average intelligence?
Yeah, I believe from that report, he had a full-scale IQ of 94, which would be in the average range. He had a nonverbal IQ, I believe, of 100. And then he had a verbal IQ of, it was illegible to me, but I'm guessing around 90, based on his full scale being 94 and his nonverbal being 100. But he had learning disabilities. So he had average intelligence, but learning disabilities in math and reading.
So then and now, he is of average intelligence, correct?
Well, he certainly was then. I have no reason to believe that necessarily has changed, although given my concerns about brain dysfunction, it's certainly possible. But I think our best guess would be to go based on the past test records that placed his full-scale IQ at 94.
And you didn't feel it necessary to give him another IQ test, correct?
I did not.
The report also in the Bindover, upon your review of that, and actually you looked at some of the other reports over the lunch hour, correct?
I did.
And has he ever been diagnosed with a psychosis?
I'm not aware of him ever being diagnosed with a psychotic disorder, and I certainly don't believe at this point in time he has a psychotic disorder.
And he's never been diagnosed with schizophrenia, correct?
That's correct.
He's not been diagnosed with bipolar disorder.
Correct.
But consistent with your diagnosis, from the very beginning to the present time, the diagnosis has been an anti-personality disorder.
Several people have diagnosed antisocial personality disorder, yes.
And that's your diagnosis here today.
That's one of my diagnoses, yes, and I think an important one, primary one.
And if I may approach the witness, Your Honor.
You may.
Doctor, I have just shown Mr. Thomas an item this morning for purposes of identification of the state's exhibit G.G. George. And if you could take a look at that, and then I have a question or two for you.
Okay, I've reviewed it.
Now, you, as a psychologist, are familiar with the Diagnostic and Statistical Manual 5 that's used for diagnosis.
I am.
And is this personality disorder we're talking about one of the diagnoses in that manual?
Are you saying is antisocial personality disorder
Correct.
listed in that manual?
Yes.
Yes, it is.
And are there certain criteria that are listed to qualify for that diagnosis?
There are.
And certain symptoms that can be observed that would justify that kind of diagnosis?
That's correct.
And on State's Exhibit GG, does that accurately, in your mind, set forth the kinds of symptoms and criteria that DSM-5 sets forth for that diagnosis?
These are not the diagnostic criteria. These, I assume, are somebody's summary of those criteria. But these are not, this is not the language in the Diagnostic and Statistical Manual.
Can you tell the jury what the criteria are for that diagnosis?
Sure. As I was saying, I think earlier, one is that, well, let me back up. First of all, in order to be diagnosed with antisocial personality disorder, you have to have met the diagnostic criteria for conduct disorder prior to age 15. So everybody who has antisocial personality disorder will have had a conduct disorder.
And the
But not-
defendant had the conduct disorder to qualify prior to age 15 for the subsequent
I believe so.
diagnosis.
Yes, I believe so, and I think others believe so as well. And then once you have that, you look for an enduring pattern in their adulthood of a certain number of other things, including, for example, violating rules and laws.
And the defendant will qualify with his background of violating rules and laws.
He would definitely qualify for that.
And what would the next one be?
Having a history of irritability or aggressiveness, he would qualify for that one as well. Engaging in reckless behavior, disregarding the safety of yourself or others, he would qualify for that one. And then having a history of being deceptive, lying and or stealing, he would qualify for that one as
And he
well.
fits that
He does.
criteria. And the other psychologists at the prison system regularly identified manipulation and lying by him as part of that criteria for their diagnosis, correct?
They didn't always identify what criteria they said he met, but I would work under, I think it's a fair assumption that that was part of what they were considering.
And the kinds of conduct he's engaged in that we've described from prison also fits into a continuing anti-personality, that criteria for that diagnosis.
Yes, I believe that's accurate.
And if we talk about causation, you're familiar with causation as a standard. You're both a lawyer and a psychologist, correct?
Sure.
On the night of January 28th of 2018, as he's walking into Rachael Anderson's apartment, is this
Okay. Please approach.
I'd like to finish the question, Your Honor, before the judge.
Well, let's go ahead and deal with it before you get through with your question. Excuse us, ladies and gentlemen. Again, ladies and gentlemen, thank you for your patience. This is the part that you never see on television. So, Mr. O'Brien, if we would just rephrase the question.
Yes, thank you, Your Honor. Yes, Dr. Stinson, would you consider your diagnosis and the criteria that we just went through, does that qualify as a mental disease?
Well, I suppose, I don't want to be cagey, but I suppose it depends on how you define mental disease. It's certainly in the diagnostic manual as a mental illness. I know under certain legal concepts it's excluded from a mental disease for proceedings unrelated to what we're talking about here today. So if you tell me your definition of mental disease, I'll tell you whether I think it fits or not. You know the criteria. So if that fits, it fits. If it doesn't, it doesn't. We don't typically think of mental disease. We think of diagnosis based on the Diagnostic and Statistical Manual.
And I guess what I'm trying to get at, do you consider your diagnosis of Anthony Pardon that you've described for us, do you consider that a mental disease that you've given us?
I would call that a personality disorder. I'd call the post-traumatic stress disorder and depression a mental illness. If you're using I don't use the term mental disease in clinical diagnosing. That's more of a legal term. I haven't seen it used in these types of proceedings. I've seen it used, for example, in insanity proceedings. So I'm not sure how you're using that term, but I wouldn't use that term. I would use mental illness and personality disorders.
And would it qualify as a mental illness?
I would consider it a personality disorder, and then the PTSD and depression would be considered mental illnesses.
Okay, we're not talking about PTSD, Dr. Stinson. I asked you very specifically, do you consider the personality disorder that you diagnosed in this case to be a mental disease?
And I don't want to be difficult. You tell me how you're defining mental disease, and I'll let you know. I don't use that term. I don't use mental disease. So perhaps, depending on how you're defining it.
Well, that will be an instruction the judge will give the jury in this case, and so I'm asking you as an expert witness in this case whether you consider your diagnosis a mental disease. And I take it from your discussion you aren't willing to do that.
I don't know, because I don't know the instruction you're going to get on how they're defining mental disease for these proceedings.
How about a mental defect? Would you consider your diagnosis the result of a mental defect?
Not the way I would typically use the word mental defect, I would not.
Now, you said that PTSD is a diagnosis, however, you would describe as a mental disease.
As a mental illness.
Mental illness? Okay. You don't like the word mental disease, is that correct?
We don't have a definition of mental disease in the DSM. It's typically a legal term. I know exactly how it's defined in insanity cases. I don't know how it's being defined in today's case.
Okay, well, that's fair enough. But PTSD, post-traumatic stress syndrome, would qualify as a mental illness, correct?
I believe so, yes.
And out of all these previous psychological reports that you reviewed from the prison system, were there any diagnoses for PTSD in those?
I do not believe that any of the older reports diagnosed PTSD. And then, of course, for some of them, PTSD had just started being diagnosed, and that diagnosis has evolved over time. So the criteria would be different today than it was back then.
In the alcohol use that we talked about, did you have a chance to, among the items you reviewed, see the defendant was stopped the day before this offense by a highway patrolman driving a motor vehicle?
I don't recall seeing that in writing, though I do believe I was told about that. And I don't recall if he told me or if his lawyers told me, so I'm vaguely familiar with that, but I don't believe I read that anywhere.
I think that would have been among documents or items, particularly the CD that were included with the material that you referenced in your report. I think he
I'm fairly confident I didn't read that in the stuff that was on the disc, because that would have been the last couple of days. This is something I'm vaguely familiar with that I was told early on about it.
Well, I guess my point is you're aware he was not arrested for driving under the influence of alcohol the night before this offense, correct?
I believe that's accurate, yes.
And did you, when you talked to his sister, did you ask her if he consumed alcohol on 15th Avenue while he was living there?
I didn't ask specifically about 15th Avenue while he was living there. She told me that everybody in the family drank and used drugs, including him.
That was historical information, correct, in some instances?
Well, in all instances, I don't think she wasn't thinking about the future. We were talking about the past.
Well, I was talking about the current, on or about the time that we're concerned with in this courtroom. Did she say he had been drinking in and around that time excessively?
I didn't get that specific information.
And you didn't talk to his mother, so you couldn't ask her that, correct?
That's correct.
And you didn't talk to the girlfriend that lived where the victim resided, so as to ask her that question, correct?
That's correct as well.
Did you ever meet the girlfriend's daughter that used to live next door to Rachael Anderson?
I did not.
You didn't talk to her, correct?
No. I believe she was one of the individuals I recommended that the investigators speak to or put me in contact with, and that never happened.
But when he came here from Georgia, he did have a place to live, correct, with mom and sister on 15th?
That's my understanding.
Did he have a job?
I don't believe he did have a job.
Did he have a driver's license?
That I don't know.
You aware of the incident where he went to the state house to seek assistance in getting a driver's license after that highway patrol stop?
I knew that he went to get an identification. I didn't know if he was going for a driver's license or if he was just going for a state ID badge, but I was aware that he was frustrated about having some difficulty getting an identification.
His mother testified that he came out of prison with the ability of training for plumbers, barbers, and electricians. And I heard you yesterday say he didn't have vocational skills. Which is it? Do you know?
I do think he did some barber stuff in prison. I'm not aware of him being an electrician or a plumber.
Was he seeking employment as a barber? Are you aware?
My understanding is he wasn't real sure how to get employed because of his felony record. He thought that pretty much would be collateral damage and interfere with his ability to seek employment.
Did he advise you whether or not he was using drugs at or around the time of these incidents?
He did not.
And the diagnosis regarding marijuana abuse, would that enter into the conduct at or around the time of this offense?
I'm not real sure how to answer that. I suppose if he was under the influence of marijuana, it could have impaired his thinking or his judgment. I don't have any information about, whether he was using marijuana, whether it was laced with another drug. If that did impact his thinking, his reasoning, his behaviors, I just don't know that as I sit here.
He did not tell you that he was using marijuana at or around the time of that offense, did he?
Right. We didn't talk specifically about the offenses because for my job in a mitigation case, I work under the assumption that if I'm going to be in court, he did what he's convicted of, and so I don't go into those details.
I guess my point, doctor, is you've diagnosed him with a marijuana and alcohol history and abuse diagnosis, and I'm trying to determine whether you have any information whatsoever that at or around the time of this offense he was abusing, misusing alcohol and marijuana excessively.
So just for clarification, I did not diagnose cannabis use disorder or marijuana.
It's just alcohol.
Just alcohol.
Others had.
Others have diagnosed
Correct.
Cannabis use disorder. I just didn't have the information that would be necessary to say that he satisfied that diagnostic criteria. I diagnosed alcohol use disorder, and based on his report of the frequency of his use, is he was using daily leading up to and at the time of the offense is charged.
He did not tell you, however, he was using it the day of the offense.
Well, he told me he was using daily. I didn't get into the specifics about that specific day, how long before, but he definitely reported that he was using excessively and daily.
Well, wouldn't it be important to you to determine if you made that diagnosis, whether he's under the influence of marijuana or alcohol at the time of this offense?
Well,
Right now, overruled.
my job is not to determine, did he do this, or is he excused from doing it? Is he not guilty by reason of insanity? My job, when I do a mitigation evaluation, is to assume that he has done what he's accused of doing, he's going to be convicted of it. And then as a mitigation evaluator, I come in after the trial, after you all have decided that he's guilty, and I talk about how might he have gotten to his lot in life, looking back over the course of his life. This stuff I talked about in my presentation yesterday. So I don't see it as my role to determine, was he under the influence of alcohol, or was he not guilty by reason of insanity, or is he somehow incompetent? That's a different type of evaluation that I'm not enlisted to do.
Okay, well, thank you, Dr. Stinson. Let me ask you this. You referenced his imprisonment at Lucasville during the time of the prison riot on April 13th, 1993, correct?
Yes, correct.
He was in that prison that housed thousands of people, correct?
That's my understanding, yes.
The riot was in L Block, correct?
I'll have to take your word for that. I have to look that up to know with certainty what block that the riot took place in.
Did the record show he was not housed in L Block?
I don't believe he was actually in the block that was taken over, but he certainly was in
The prison.
the prison that got locked down and that caused, obviously 10 deaths, and, armed forces, including the National Guard, to arrive on the prison grounds.
I guess my point is, in terms of exposure to traumatic incidents, he did not witness any of those murders in L Block because he didn't live in L Block, correct?
I don't know that he was an eyewitness, but if you're suggesting that because he was only in another part of the prison where this was going on, that wasn't somehow traumatic, would be, I think, a huge misunderstanding of how trauma can work. It's as if to say, the next courtroom over blows up, and we're not going to be impacted by that because we weren't in that courtroom. Of course you're going to be impacted if you're behind closed walls that have been taken over by inmates, and 9 inmates and 1 guard are killed, and they're thrown out into the yard to be recovered by the police. I don't know that he was in that block, but certainly that would have been a potentially traumatic experience for anybody in that prison.
And that's your testimony, that anybody in the thousands of people in the prison, that would have been a traumatic adult experience that would affect him in the manner that you diagnosed him going forward?
That's not what I said. What I said is it could have been traumatic for them. Would have it affected every single person in the same way? Absolutely not. Not everybody that goes to war is affected the same way. Not everybody that was involved in 9/11 in New York City was affected the same way. But what I wanted to caution against is assuming that because he wasn't on the block that was taken over, that somehow that had no impact and couldn't have had an impact. That would be an unfair statement.
Excuse me, after that riot, he was in fact disciplined, wasn't he, for misrepresenting information about that riot?
I don't know that. I'll take your word for that. I did not see that.
In the adverse childhood experience formula that you gave us up here earlier, is it true that originally was created and designed to look into whether those children would suffer adverse health consequences when they grew up?
Yeah, that's exactly how it was originally developed. It was a large study done by Kaiser Permanente, and basically looking at insureds and asking them to identify what kinds of adverse childhood experiences they had, and then determining whether or not that had an impact on future health risk, cardiac arrests, or cardiac issues, blood pressures, there's a whole bunch of health risks. And what they identified is not only did it have an impact on physical health, it had a huge impact on mental health.
And emotional health, correct?
Mental and emotional, I think of as synonymous with each other, so yes.
And isn't it true that someone with a high ACEs number, as you have described, can do remarkably well in their adult life?
Sure. I don't know that I've interacted with anyone that had 9 ACEs that was doing remarkably well, but is it theoretically possible? Sure. Is it impossible for someone with a lot of ACEs to not turn out okay? It's not impossible. As I said yesterday, it's a dose-specific response. The more you have, the greater the risk you're going to have a bad outcome.
Others in Anthony Pardon's home were raised in that same environment, correct?
To some extent, they were, when Mom went to prison when Tony was 8, some of them went and lived with family members, some of them went and lived other places. Tony, ended up institutionalized, but at least to some extent, they were for a few years all under the same roof.
Same mother, same father?
All but one sister. One sister had a different father, the oldest sister.
Same mother and father with the kind of abuse issues we've talked about?
Not exactly the same. The siblings and the mom said that Tony and one brother took the brunt of the abuse, so they didn't obviously all have the same experiences. That's not uncommon in an abusive household, that the abuse isn't doled out equally. But Tony and one of his brothers in particular seemed to take the brunt of the abuse from his dad.
You saw letters in the prison records from Deborah Pardon and Loretta Pardon to the parole board asking that Anthony be paroled at different times, correct?
I saw one letter from Loretta, his mom. I don't believe I saw any letters from Deborah.
We heard about a letter from Deborah when she testified, and I guess my reason for asking that, have you found that usually family members of someone in Anthony Pardon's situation are ready, willing, and able to come forward with exculpatory kind of information about childhood?
Sometimes they are, sometimes they aren't. Sometimes families are very supportive of their family member. Sometimes they are not. Sometimes they provide information that they think will be helpful. Sometimes they provide information that they think won't be helpful. So I think it varies from family to family and probably from family member to family member.
And in this case, you're aware Deborah and Loretta both testified at this mitigation hearing, correct? Would you call that supportive?
It certainly shows some sign of support, given our efforts to meet with and talk with the family. I wouldn't describe them overall as supportive of Tony, but I will give them credit for at least being here.
They both visited him frequently in the jail, didn't they?
I said earlier I didn't get the jail records. I will assume from your representation that perhaps they did.
You're not aware of whether or not other family members visited him then either, correct?
I'm not. Again, I requested the jail records, and unfortunately we have not received them.
Doctor, you referenced when you testified on direct exam about the work you do, and sometimes you work for the state, sometimes you work for the defendant. Have you ever worked for the prosecutor in a case like this?
Meaning a capital case?
Correct.
Yeah, I have.
Where would that have been?
I use prosecutors in Lorain County have hired me on death penalty cases in the past. In fact, I've got an open case with the Lorain County Prosecutor's Office and a death penalty case up there right now.
What say you at Lorain County?
Lorain County.
And is that for mitigation?
Well, prosecutors don't typically hire mitigation psychologists because mitigation by statute is a defense issue. But the defense in those cases hire mitigation psychologists, and the prosecutor's office asked me to review the work to make sure that it was completed consistent with the standards in the field, and let them know if there are any issues that they should be aware of or concerned about in that mitigation psychologist work.
And is that the only time that you've been worked with the prosecutor on a capital case?
I've been involved with other prosecutors' offices in capital cases, but not with death specs. Or, I'm sorry, in aggravated murder cases, but not with death specs, so not capital cases.
Okay, is that correct? Now, you do present seminars to defense attorneys for death penalty cases, don't you?
I've presented at the Ohio Association of Criminal Defense Lawyers Death Penalty Seminar each of the last 2 years on the role of psychologists, very much like I said, you know, Mark Cunningham has produced a lot of stuff on how psychologists should be used. I present that to attorneys so that they're using the psychologists appropriately in those roles. So yes.
And last November, here in Columbus, you presented at the Ohio Association of Criminal Defense Lawyers annual death penalty seminar, didn't you?
Yes, last year and then the year before both, actually.
Do you remember the subject of your presentation?
I won't recall the title. I was part of a panel discussion, and so my responsibility was to talk about the role of a forensic psychologist in doing death penalty mitigation evaluations.
And you were on a panel with 2 other lawyers, is that correct?
So this last year, it was 2 other lawyers, and the year before, it was 2 other lawyers and a mitigation specialist.
If I asked you whether or not the subject was presenting on effective mitigation cases, would that be accurate, you think?
Yeah, I think that's fair. My role is to talk about how do you do an effective psychological evaluation and mitigation cases. What does that involve? Ironically, I'm here testifying. I wasn't able to review a bunch of records. One of the things I would say is you should review as many records as you can. So, yeah, that was my role, is to talk about what you need to do an effective job in your role as a mitigation psychologist. What that looks like.
If I could approach the witness, John.
You may.
Dr. Stinson, I'm going to hand you what's marked as State's Exhibit HH. Does that appear the brochure that was sent out by the Criminal Defense Lawyers Association for that seminar?
Yes, you may.
Dr. Stinson, that State's Exhibit HH is an accurate brochure of that presentation?
I would have no way of knowing. I've never seen the brochure. I'm not on their mailing list, and I didn't get a copy of the brochure.
I may approach the witness, Your Honor.
You may.
Well, the brochure appears to be a brochure that was sent out by the Ohio Association of Criminal Defense Lawyers. That's who put it on, correct?
My understanding is that is who put it on. That's who sponsors that seminar.
And that's who asked you to attend, didn't they?
Actually, I was asked by I think the association, no one representing the association called me. It was one of the attorneys who was asked to be on a panel, said, hey, will you present on the role of a psychologist? We think that would round out the panel.
Okay, and at least on this brochure, do you remember being part of the Friday, November 22nd, 19 presentation entitled Presenting on Effective Mitigation Case?
That sounds correct. I don't have a specific recollection.
Well, do you remember being there?
Well, yeah, I don't remember exactly what date it was, but sure, I was there and presented. But if you're asking me,
how many people were in attendance at this criminal defense lawyer presentation on how to present an effective mitigation case?
I have no way of knowing that.
More than 50?
I would assume so. It was it's kind of a larger room.
Okay, I have no other questions. Thank you, Dr. Stinson. Mr. Thomas Mann, can redirect.
Thank you, Mr. Bryant. Redirect.
Thank you, Your Honor. Dr. Stinson, you were shown Since you were given and asked questions about several reports from psychologists who had evaluated Anthony Parton, is that correct?
Yes, that's correct.
And you had been asked questions in terms of evaluations that had taken place back in the early 80s, 1982, some evaluations that took place 1983, I think 99. You were asked about a Dr. Esbar report. Do you recall that?
I do.
Now, when you were able to review all of those reports, so that you're as clear, was your diagnosis in this case any different?
Well, certainly the antisocial personality disorder was no different. The idea that there was some substance use disorder seemed to be in agreement. The actual symptoms were very similar. I made the diagnosis, for example, of post-traumatic stress disorder. We did not see that in the earlier reports, although they described the symptoms. Now, you have to understand that PTSD made its way into the diagnostic categories for the first time in 1980. And at that point in time, PTSD was really talking about people coming back from war or coming back from being tortured, or maybe large-scale industrial accidents like explosions or perhaps really bad car accidents. So in those days, in the early 80s and then through the 80s, PTSD was different than how we understand it today. So what we see today is through research and through evidence-based studies, the diagnosis changed over time. We had the first revision to the diagnosis in 1987, and then another revision in 94, yet another revision in 2000, and the most recent revision was in 2013. And in 2013 is when they added, based on the evidence from the literature and studies that have been done, realized that really the prominent mood state in PTSD is this irritability and depression, and self-destructive behavior is an important component of it as well. Anger, aggression, recklessness. And so, although the same things were described back in the 80s and 90s, they might not have made the diagnosis for various reasons. But one very plausible reason is the diagnostic criteria were different than they are now. But the problems were the same.
You may.
I'm going to show you what's been marked for identification purposes, stated as in FF. Have you seen that?
Yes, I've seen this.
And is that one of the reports that Mr. O'Brien handed you?
Yes, this is the one that was given to me after testimony yesterday, and I reviewed it last night.
And when was that report? Can you tell?
This was, the interviews happened with Tony in December 1981.
Turn to the last page and give us what is the psychological diagnosis of Anthony in 81?
Aggressive antisocial personality disorder, mild identity neurosis, learning disability, functional dyslexia.
Now, you didn't write this report, did you?
I did not write that report.
And the report from Dr. Esbar with his diagnosis, you didn't write that, did you?
I did not write it.
And so what you showed these people that you did in 2020 mirrors what all the psychiatrists said about Anthony back in the 80s and 90s. Is that correct?
Objection, Your Honor.
Oh, please approach.
Your Honor, I'll withdraw the question.
Okay, questions withdrawn.
I'll withdraw. Were you presented with any report that would contradict your diagnosis of Anthony Park?
I would go one step further. I would say not only is the new information that was made available to me, does it not contradict what I came up with, it in very large part supports and buttresses what I understood and what I said about Tony.
You don't have any doubt that Anthony Pardon in 1993, when the riots took place, was at Lucasville, do you?
I have no reason to doubt that. That is my understanding that he was there.
There's been no information presented here to show that Anthony Pardon was not at Lucasville in 1993, has it?
Correct.
You were presenting these folks with the adverse childhood experiences in your evaluation of one individual, is that correct?
That's correct. Obviously, my focus was on Tony Pardon.
So everybody else, you never evaluated anybody else using any of that criteria, did you?
That's correct.
And when you told these people what your findings and evaluation was, that was concerning one individual, and that's Anthony Pardon, is that correct?
That's correct.
Do you have any doubt that the adverse childhood experiences, could we go back to the slide on the adverse childhood experiences?
You gotta give us a little more heads up for that one there.
My bad. My bad. I can probably do it. You got a color? Well, I just use this. Thank you very much, Your Honor.
Give me a second.
Okay. You recall that? Oh, that was so much. That's all right.
There you go.
Oh, thank you, Your Honor.
You need the lights?
I'll ask the members, can you see? Can y'all see? Very good? Okay. No, Your Honor, thank you very much. This is the adverse childhood experience, is that correct?
That's correct.
And I think when you did your individual evaluation of Anthony Park, when you, and I'm going to turn this over, when you checked off and explained to the members of this jury that this is your finding, that hasn't changed, has it?
That has not changed. I feel confident in this assessment.
And is this based on something that you invented, or is this something, as I think Mr. Bryan said, that came from a different type of study, but it was also applicable to mental studies?
Now, this was a study that was started a long time ago by a large insurance company, essentially, but the findings have been sent out to healthcare professionals and psychologists and people like me through the Centers for Disease Control, through a kind of public campaign for us to be more aware of adverse childhood experiences and the lifetime effect they have on health, physical health, risk behaviors, mental health.
So that's not something that you invented, that's something that you took that criteria and applied it objectively to Anthony Park, is that correct?
That's correct.
And then wherever you got checks, that would be information that you received and information that could have possibly, because you weren't here for other testimony, been testified by other family members.
Fair enough, yes.
I think you indicated that you have an open case, is that Lorain County?
Yes, sir.
And you are hired by Lorain County, so that if that prosecutor there feels that a mitigation specialist or a psychiatrist is not giving the correct information, you can check that work. Is that correct?
That's a fair way of putting it, yes.
So prosecutors can actually hire somebody if they disagree with the mitigation specialist, and they can come in and tell these folks. Is that right?
That's correct.
Your testimony, after reviewing all these documents that were presented, is your testimony to these folks still the same?
My testimony is exactly the same. I've presented what I think are important mitigation variables, including the history of child abuse and child neglect, the family history of drug and alcohol problems and mental health problems and legal problems, the adverse childhood experiences, his development of his own drug and alcohol problems, personality disorder and mental health problems, the multi-systemic failure, which I said was not on my slides, but I think it's important to emphasize that you know, the school systems saw the writing on the wall, but were unable to stop it. Children's Services was ineffective at providing anything that would intervene. The juvenile court system bound them over to the adult system. The adult system provided essentially no services. State parole systems, you know, this is your guy now, we're not worried about it. Well, he was yours when it started, so we'll just follow your plan, even though it didn't include any of the recommendations from multiple evaluations. So all of those things, I think, remain important mitigating variables in this case. And the visual that I concluded with, which is this is what we wanted, a strong foundation with a protective wall. That's what you want for any person. And what we got in this case was a stripped away foundation, no protection, and a bunch of negative influences pushing us towards, unfortunately, a very tragic outcome.
And in all the psychological reports you read, each and every one of the psychologists identified and put in the report the need for Anthony to have certain types of treatment. Is that correct?
That's a fair statement.
And at no time did he receive any of those treatments.
I did not.
Sustained, it was to leave.
Your Honor, grab a minute.
You may.
Dr. Stinson, thank you very much. Thank you very much, Your Honor.
Thank you, Mr. Tom. Rick Ross?
No, Your Honor. Thank you, Dr. Stinson.
Thank you.
You can step.
Thank you, sir.
Your Honor, may we approve?